We filed 2 applications on behalf of Corporal James in the Supreme Court last week, Friday. And those applications were, one, to have the interdiction quashed by way of judicial review. And in the interim, we sought a stay of the order to put him on interdiction. So there are 2 separate applications. When the matter came on yesterday and today, the court started the hearing. The judge was of the view that I was raising some very important constitutional issues touching on concerning the application, because we are saying that what the police high command did was an infringement of his constitutional right. So we were raising some constitutional law principles to show that the charges are illegal. And the judge was of the view that these are important points and should have liked to hear from the Attorney General. Was of the view that the case should be adjourned to facilitate the Attorney General being brought into the case, even though the Attorney General is not a party to the proceedings. We did not think that was the approach to be taken, because the judicial review proceedings are against the decision maker, in this case, Mr. Lewis, who served Mr. James with the interdiction. The judge was of the view that she wanted to hear on these constitutional issues. So she adjourned the case to the 28th of September. We made submissions about the unlawfulness of the deprivation of his salary. The court got the other side to agree, having heard our submission in law. The other side had to agree to increase his salary to 99%, almost 100%. And secondly, to stop the disciplinary proceedings against him until the matter is heard. We are of the view that that is good. We are saying that he ought to be reinstated immediately so that he can perform those functions he was elected to perform as chairman of the Federation. So she granted us almost everything except that one. So we are going to the Court of Appeal on that simple point as to whether he should be immediately reinstated until the case is heard.